in the matter of Elbert at all. So if council's ready, come on up. Good morning, council. Is it Mr. Guile? Giel. Mr. Giel, good morning.
Good morning, Your Honor.
You've reserved 3 minutes for rebuttal, so whenever you're ready.
I may use all of it in the opening argument.
Okay.
We'll see.
And take your time.
Good morning, Your Honors, and may it please the court, Grant Giel on behalf of the appellants. I'm going to briefly cover the factual pattern here, but as the court has stated, you're familiar with the fact pattern, and I do not believe that it's actually particularly relevant to the main thrust of our argument. We do have a legal component to the argument, legal/factual, with regards to use categories that I'll speak about at the end. But the main argument that we have before this court is one of articulation. The underlying cases were 2 SDPs, site development plans, that were brought before the Charles County Planning Commission in late 2022 over the course of 2 hearings, and had approved different developments for an Amazon parking facility and an Amazon warehouse at 2 different addresses relatively close to each other. The SDPs were approved in an area, planned unit development called Smallwood Village, which has its own little master plan and its own docket 90 is what they call it. It's kind of like a bubble ordinance that works concurrently with the general code of ordinances for Charles County. Different seas. Charles County. And the Planning Commission had received a letter from the Smallwood Village Planning Design and Review Board approving these uses. That was the first instance of any administrative approval. Then it went to technical staff, which issued technical staff reports, and then the Planning Commission held an oral vote for each one of these independent PUDs over the course of 2 hearings, voted for it, submitted it, and stated in its minutes that those votes had occurred. While doing so, it did not issue any actual written determination of its findings of fact or law.
But they did at least say that that the findings and recommendations were included in the staff report.
Absolutely,
right?
Your Honor.
And how do you get around the most recent, I guess, or I'm not sure it's the most recent, but I think that you recognized and tried to address the Baden, Greater Baden case, where the court seems to suggest that at least referencing the findings of the staff, even though it's not the best practice, that we're going to find that it's sufficient to allow a court to review the findings and conclusions of the agency.
Well, I'll go over this in more detail, but to answer your question poignantly, I believe that case and other cases around it stand for the proposition that you can incorporate a technical staff report if the technical staff report is itself sufficiently thorough and legally based, and that we do not believe in this case that it is. But also that should come concurrently with some sort of analysis, and you shouldn't simply copy and paste wholesale an entire technical staff report and say, that's what we're deciding.
Well, here they didn't even do that, though, right? They didn't copy and paste anything. They just referenced it without saying, these are our findings and conclusions. They just referenced the report.
I consider that to be theoretically the same as copy and pasting. They're saying, this is what was decided. We are going to say that what was decided is what we decided. They didn't physically copy paste it into a written document, and I think that that's the main issue here. But they did say
it's pretty common in various administrative law contexts for a deciding body or deciding person to adopt a staff report.
Absolutely, Your Honor. It is commonplace to adopt a staff report, but in my practice in land use and my firm's practice in land use, we did not know of a single instance where they only copied a staff report. There's the final fact finder has always had some sort of at least minimal writing to say, this is what we've decided and this is why we've decided it. And then they say in their determinations, also we are incorporating what technical staff has said, or sometimes they don't do that. But it is common for them to reference a staff report. It's not common in my mind for them to only reference a staff report. And I do think that that is the main crux of our argument here, is that you're familiar with the standard of review for an administrative practice, articulation, substantial evidence, arbitrary and capriciousness, legal error. And
Doesn't there have to be substantial evidence in the record? And couldn't
Yes.
we just look at the record and see the staff report and say, that's substantial enough?
No, Your Honor, I don't believe that the court is actually able to do that, and has said in itself that it is not supposed to scour the record to try to find a rationale for a particular administrative body's findings.
But if that's the only rationale, we wouldn't be scouring the record.
I don't think that you'd be able to scour the record because there's no actual determination for you to analyze. And I think that's the main threshold that you need to get past first, is you first need a document that says, this is what we found and these are the reasons we found it, so that a person who wants to figure out what the determination was and possibly challenge it can see what was determined. And then a court can say, they determined this, we'll see whether or not it's justified. And we don't have that.
And staff, I'm sorry.
No, you go ahead.
The staff report did not deal with the question of whether these uses that were being requested were permitted uses, right? I think that that in part gets to, I think, your second argument. I don't want to throw you off the course. I'm trying to understand, because I'm also struggling with the zoning tables and where this, I see the uses, and I'm trying to find out which zone really we're talking about here, because I don't see anything in the record that specifically references what zone this is in, that these uses, as whether they're permitted, special exception, or whatever, would apply to. And I don't see where either the staff report or the letter from Smallwood Village Planning and Design Board really address that either.
Just for a point of clarity, should I hear both of your questions first, or just answer this? Okay. Okay. Well, this is a twofold issue, because what we're arguing with regards to the use categories is that this is a legal error distinct from any articulation issue, because we do know what the use categories were, like what the relevant administrative fact finders were relying on. And I would need to see if there is an underlying zoning category here, but the PUD is kind of an overlay development that allows for particular uses to occur in that little area. And the reason that we don't go into details as to the zoning categories is that I don't believe that there's any question as to whether or not they did in fact use those uses. They believe that those uses were the ones that were applicable for the site, and that's what the uses that were applied for. And if there is a conflict between those uses and the underlying zone, it's not really relevant for this case, because what we're actually discussing on that matter is whether or not the use applied for works with or conflicts with the use cited. But that's not what we are arguing with regards to articulation. With regards to articulation, we have an underlying legal argument about the conflicts of docket 90, the master plan, et cetera, that are not before this court because we didn't get the chance to see whether or not they had made a factual or legal determination in their ruling. I have that on hand. I don't think that it's relevant because we're not really getting into questions of whether or not they are legally correct in their decision. The question is whether or not they were able to issue a decision in the manner they did so. And if they were, then the decision stands, and if they were not, then we've asked for reversal, but I think remand would also be appropriate. It would go back down, and then they would issue a written decision, and then we would argue whether or not it was legally correct based on docket 90. But that's why those those two legal arguments, I believe, are distinct.
Just to clarify, one thing that Judge Storm asked you earlier, what authority are you relying on that says that the planning board has to issue a written set of findings and conclusions?
We have the general common law of Maryland administrative practice, which Appellee would argue, or has argued in the past at least, is only applicable to legislative bodies. I believe that there are several cases that talk about other local zoning boards, talk about other planning commissions, talks about the Maryland National Capital Park and Planning Commission, which I would, of course, state is a discrete entity. It is not exactly the same thing as a planning commission in another county, but it's still a similar principle of administrative planning commission that does not function as a legislative body like a group of county commissioners. So we have that general common law, and then we have Maryland land use article, I believe, 2105, which states that a planning commission is expected to maintain records of its findings, of its deliberations, et cetera. And
Satisfied that part of it.
I don't think that they did have a record of their findings because they didn't issue their own findings. They simply said, here are minutes, and this is what we find with the planning commission.
Well, but on the record, they voted to adopt the report.
Yes.
Right? At the end of the transcript, there was a motion, and they voted unanimously to adopt the staff report.
Yes.
So why isn't that, to Judge Wells's point, Chief Judge Wells's point, why isn't that enough of a
written finding?
Well, I mean, there's two distinct questions. There's the record keeping part seems to be covered if it's done on the record, right?
The record keeping, in my mind, when I look at keeping records, I expect there to be a written finding and for them to maintain a written documentation that says this is what we found, as opposed to the minutes, which by themselves would simply say, we voted, and there would be no transcript but for the fact that there was a challenge to that, and we ordered the transcripts. Normally, those transcripts would not be produced by themselves.
You don't think a writing that says, for the reasons stated on the record, or the memorializing the fact that there was a motion and a vote on the record, you don't think that's enough? You think there has to be a separate writing, even based, regardless of whatever's conducted on the record, you think there has to be a whole separate writing?
Yes, Your
in
Honor.
every case is a matter of state common law in every administrative proceeding? I mean, that's not consistent with the way administrative law works in Maryland.
Well, for
I mean, I can recall 5 years at a particular agency that made decisions all the time on the record that were noted in sort of broader minutes about what was decided and not separately memorialized. There might have been a letter that said, you know, for the reasons stated on the record, the motion's denied, or something like that. But I mean, there's a lot of administrative law in Maryland that's conducted in the way this is conducted here. May not be best practice, may not be, and there are different contexts where there's a statute or there's a regulation that says otherwise, but you're not pointing to any of those. Right?
I believe that for a final fact finder, you are expected to have a written finding that if you're going to have a finding on the in the form of for the reasons stated on the record, that would be a record that would be produced in the normal course of business, as opposed to a record that would only be produced in the event of a challenge in the case of the transcript for this case, because otherwise there would only ever be these minutes. That there was no record from the county generally about the deliberation on like a county website or anything, and it's only because of the fact that there was a challenge that we managed to hear this transcript.
Well, if there's an application and no challenge to it, it gets approved in the normal course. I mean, there wouldn't be any reason to have a hearing if nobody challenged it, right?
I think even if there is, there would be a challenge before the administrative body. There wouldn't necessarily be a transcript prepared for the challenge before the administrative body. The transcript was prepared for the circuit court. But in the event that there is an uncontested hearing, I guess it would be a crime with no victim because nobody would be worried about it.
It's not a crime if the law doesn't say so. No, I get your point, but you're saying that as a matter of law, there's required to be this writing. And in response to a combination of the Chief's question and Judge Storm's questions, you said that authority stems from common law. One thing I've learned from hanging around here 10 years and doing different land use cases is that every county is totally different. And a lot of counties have regulations or ordinances or specific procedures that everybody gets to fight about whether this time there's nobody's pointing to any Charles County ordinance, nobody's pointing to any text of law, right? No state statute, no Charles County ordinance, no regulation to support this articulation theory of yours. It's all coming out of the broader common law of mostly land use, but kind of administrative law more generally.
Well, Your Honor, I do think that the state article, the records for findings, you say that it could possibly encompass these minutes. I don't believe that it does. And I do think, therefore, that I have pointed to an overarching state statute which talks about the responsibilities of planning commissions and says they must maintain the records of their findings, and that the minutes summarizing a vote do not meet that threshold.
Okay. Can you get to the second issue?
Yes, I'll get to the second issue very quickly. The second issue is in regards to use categories and applied for uses. And I state very briefly, since time is of the essence, that our firm has been before the Supreme Court as of last year for a similar matter. I want to state this for posterity. Crawford versus the County Council of Prince George's County, where we did argue a similar matter. And I don't recall it being referenced in our briefs, but I think that it is important for this court because that's recent jurisprudence for them to understand. That's been decided. That there was another issue about Amazon warehouses and about uses applied for and uses cited, and our argument was that the uses applied for did not fit the uses cited. The court in that case determined in favor of Amazon and of the county council. We believe that this case is discrete in two manners. One, in regards to the fact that that was a substantial evidence review because there was in fact a written decision, findings of fact about how the use applied for would fit with the use cited. And this one, I can't point to a decision and therefore can't say, well, they decided this because of this. And unlike the general articulation argument you stated earlier, at no point in any of the administrative process did anyone actually talk about their rationale for these uses applied for. They simply said, these are the uses applied for, these are the uses cited, we think it's fine. PDRB didn't explain it, the staff report didn't explain it, the Planning Commission didn't explain it. So there's no substantial evidence to point to in the record for somebody saying, this is why I think that the use applied for should fit with the use cited. And I'm going to just note generally, I'll lead into some of my rebuttal to answer you fully on this. The second distinction, I believe, is in regards to the actual definitions themselves. In Crawford, and I don't mean to disparage my own arguments or the arguments of the county council, it was semantic in a matter. They were saying, here's a warehouse use. And we said, this is not a warehouse because it has these factors that are not relevant to warehouse uses. It has higher trip factor generation. It has greater hours of operation, et cetera. And ultimately, the court said, look, both parties could make a colorable argument, but we're going to decide that there's substantial evidence to support the county council in its determination. Here, I believe that the definition is an axiomatic matter. There are cited uses. The cited uses are, and I quote directly here, all operations conducted entirely within fully enclosed building, all storage within completely enclosed structures, and automobile parking garages or parking lots not located on a lot where there is another principal use to which the parking is
Your
related.
argument basically is nobody really addressed that, right?
Well,
as to why the operations fit within these uses?
Well, my argument about nobody addressing it is why it's distinct from Crawford. But my argument as to why it isn't appropriate is because it doesn't matter if they address it or not. It's an axiomatic problem. The cited uses say all must be within the building. And I don't think this is a controversial statement. We know how Amazon warehouses work. They send things to people. They must necessarily have operations that are outside the building.
But there was nothing in the record about that at all, right? About Amazon.
There was general discussion about what was happening at the site.
Nobody opposed the first application. I mean, nobody was there to even address anything. And then you brought in a traffic expert at the second hearing.
That is correct, Your Honor. Nobody, well, at the circuit court, we believe that there was an issue of notice, but nobody was at the first hearing. The second hearing is when we brought this up. But the uses cited there's the external problem of there's an operation outside the building and it must necessarily be so.
What building in America doesn't have this problem? right? And people walk in and out of office buildings.
Well,
Right?
most-
People, and there's no warehouse in the world, by your definition of entirely inside, that could possibly meet that definition. Because stuff comes in and stuff goes out.
I understand, Your Honor.
The only, I mean, maybe it works for Hotel California, but it literally can't work for any other business building in the world the way you've described it.
Then they should rewrite the ordinance. Most
So
ordinances.
that's what you,
It's a definitional failure of the ordinance, sir.
so then no warehouse could possibly be approved under this ordinance?
Well, they could if they were to cite a different use and there was a different warehouse use. We didn't have a debate before any of these administrative bodies as to what other uses there could be. Only that they cited
So
these
under this
uses.
ordinance, then, your view is no warehouse could be cited in Charles County?
Under this particular use, I do not believe that operations, and you could define them as operations, not merely a person coming and going to work, but actually doing stuff in a building.
This definition?
Under this definition, you could not have an
alone,
Amazon warehouse or anything else that
could you
moves
have
in and
any
out.
warehouse in Charles County?
You could have a warehouse where all operations don't get shipped in and out, but it would be difficult. There would-
What does that mean? You keep saying it's axiomatic. How could you have any warehouse in Charles County if you can't bring things into it or take things out of it?
Do I have time to answer
Sure,
your?
you can answer the judge's
Okay.
question.
I believe that a warehouse that, for instance, would be storing logs would have the actual operation of log storage be everything
But
within
no
the
one could
building.
ever come pick up their logs, or it violates the use.
I don't think that a person coming to pick up the log would be the same thing as the business itself operating in and out of the building.
You could have a warehouse that just sits there, and the owner of something could bring it there and leave it and then come pick it up.
I
But
think-
nobody else could bring it in and out?
No, I think even the owner could bring something in or take it out in the event that that's not described as the operations of the use. I don't think.
There's not a rational definition. There's literally no business you could operate under the definition under the way you're reading that definition.
Your Honor, I don't think that it was my responsibility to cite this particular use. I don't think that it's a well-written
Okay,
use
so,
category.
but your argument is, the way you're articulating the definition, I mean, we do have a general, the law generally asks us to not read texts in ways that lead to absurd results. But that aside, the way you're reading this definition, and your argument is Charles County has effectively precluded itself from approving a warehouse in that county, because no warehouse could meet the definition if things are allowed to come in or go out.
I think under this definition particularly, buildings generally, and I don't think it's specifically really restricted to warehouses, buildings generally would not be able to operate unless the operations, the actual understanding of what the operations were, would be conducted within the building. And
That's insane. How is anything supposed to, no office building operates like that, no deli operates like, no courthouse operates like that.
I don't think that there would be.
So you're just, it's like it's a definitional fail and nothing could be approved under the definition that the county approved?
Well, I don't want to go into hypotheticals about possible uses that I think could be applied for here, especially since I'm well over time. But I just think that in this instance, this particular use, as cited, does not meet with the plain text reading of this particular use category.
Okay.
All right.
Thank you, Chief.
Panel has no other questions. Thank you very much, Mr. Keel.
And I will, of course, pass up on my rebuttal.
Mr. Elbert, you have 20 minutes.
And good morning, Your Honors. For the record, Elizabeth Theobald, Deputy County Attorney. I'm appearing on behalf of the Planning Commission. Just as a brief matter, I'm going to end up doing a lot of response to the arguments that have been brought up, but I think what I really do want to make sure is clear is that these were applications for two separate parcels of property. These two separate parcels of property were subject to, and I believe, Judge, you alluded to the fact that it is within the PUD area, which is it's actually a zoning indenture, which was established back in 1973, which basically established this area in the Smallwood Village zone as an industrial commercial area. In order to be
So in terms of the use table, you look at the commercial industrial category.
So what's very interesting about this zoning indenture is that it is also subject to its own covenants that were established back in 1973. There is the Planning, Design, and Review Board, which is referenced in the which is recorded and affects all of the properties that are within the PUD. And that Planning, Design, Review Board has very broad powers. It has the broad powers to be able to determine what structures, what uses there are that are supposed to be approved within the PUD, the planned unit development. Essentially, what they have done is they've adopted separately the table of uses that the zoning ordinance has within it, and they go ahead and apply what uses that there are. To actually note specifically, it was reported, I believe I referenced it by footnote in the brief, that it was at Liber 318, and more specifically Folio 237, which starts to describe the broad powers of that PDRB. And essentially, nothing can be done within the within St. Charles or within that St. Charles Village unless they get the preliminary approval of the PDRB. Approval does not necessarily mean that there's an analysis. It's whether or not it fits in this category. And that is exactly the information that was submitted as part of the staff report to the Planning Commission. Going back to also the...
They didn't set forth any of their analysis. They just said it fits. Right?
And actually, the covenants support that. What they just need to do is approve or disapprove. There's not an analysis that is referenced in the covenants that say that it needs to fit X or Y or Z, but what that Planning, Design, and Review Board did was adopt the rules, and the rules say we're going to rely on what it is that the county establishes are uses that are appropriate for commercial industrial zones. The
How is there ever supposed to be any judicial review of that decision?
of the Planning, Design, Review Board?
Of the approval or disapproval decision?
I don't understand that the covenants provide for one. Totally serious. It is
Purely at that earlier stage?
they are not able to, any applicant trying to apply for any use, and actually it applies to county government because I was involved with an acquisition where we intended to change the use of one of the buildings. We had to submit it to the Planning, Design, Review Board before we could even apply for the site development plan to put the property into use. So essentially, that is your first step. And what we are required to do, what the staff report is required to do, is incorporate all the procedural steps that are required to be submitted for the Planning Commission to approve it.
If it's that early in the review process, how does anyone get to challenge that, if at all?
I don't know that anybody gets to challenge it. I do believe that if it's disapproved, then the owner of the property has to go back and figure out what it is that they would like to do with the property. I'm not trying to be, flippant about it or anything, but I don't see.
So it doesn't even get, it gets cut off long before the planning board.
Yes, it could.
Without any, it could, without any opportunity for review of that. The planning board decision can be reviewed, and we can, I guess we're gonna talk about that too. But your argument is this could have been cut off within the evolution of the various sub-agencies or agencies that have to weigh in on this, and would never even get to where the planning board got to make a decision in the first place. And
Procedurally, yes.
And there'd be no review of any of that.
Procedurally, yes.
And then when the planning board makes its decision and it incorporates that letter, there's really no review of that because the planning board hasn't reviewed it in any way.
Well, the planning board, I don't believe, is in a position to be able to review it. What I understand is that, and like I said, referencing the expansive nature of the responsibilities of the Planning Review Board, it's literally, you apply here, if you are approved, you pass go, you get to move on to submit whatever site development plans, stormwater management plans that you would need to do.
What if the review board is run by somebody who has an intense personal dislike of an applicant and denies approval for that reason, has nothing to do. Let's assume for the purpose of my question that the application meets every conceivable criterion, but is denied for completely inappropriate personal reasons.
Because it's a covenant, I believe the applicant would be able to take it to court and either challenge what it is that the Planning Design Review Board has done and adopted as part of its rules and process.
Like in how, if it were true before that there's no review on the merits, how would they posture a challenge based on completely inappropriate personal vendettas?
I don't know that there is a mechanism for challenging the personal vendettas. If the personal vendetta moved to a point where there was actually a violation of what it is that should be done, then that is something that would be actionable.
Right, but they just say no. They don't say, I'm denying it because I dislike this person intensely for completely inappropriate reasons. They just say no. The application comes in, it's rejected, and we're positing that we know, we've gotten in the minds of the decision maker, and we know that it's not because of the merits. We know it's because they have some bad history.
Or the flip side of that is, well, we know it's Amazon, and so we're going to approve it because it's Amazon.
Yeah, we're going to approve it because it's Amazon, we're going to disapprove it because it's Amazon, whichever you prefer.
So that's
Assume the merits are all kosher. But either we're going to approve it because it's Amazon, or we're going to disapprove it because it's Amazon. That's not reviewable in your view, right?
That's not. I do believe that Creative Counsel would be able to take that to a circuit court.
How?
By filing a petition violating any covenants. Like I said, the covenants are pretty, even though the covenants are very broad, and it really ends up being seemingly a matter of discretion, quite frankly. But now I'm going to say, with all due respect, the county has no real control over what it is that the Planning Design Review Board is. I did not come prepared today to review their rules and processes. I know that the covenants do state very clearly that they have to adopt rules and processes. So if I am speaking out of turn as to whether or not they have something that could be reviewed or reconsidered based upon the presentation of additional evidence, I'm not part of that board.
Well, as you understand the broader planning process, there's no way to, if you flunk any of these intermediate steps, you're out. And that you don't get any judicial review until you get all the way to the end, to where we are now with this one.
I don't understand that there is not an opportunity to resubmit something with any particular changes.
But you have to resubmit it in a way that satisfies the people who said no.
I believe so.
So you think that the Planning Commission's decision simply memorialized in the minutes, that is sufficient to state, for it to make findings and conclusions that are reviewable?
I do. As I stated in the briefs, and also in arguments before the circuit court, I do believe that it's important to remember, and just as Judge Nazarian pointed out, in every county, every planning board and every planning process is different. What I do think is really pretty consistent across the board is that you have citizen members who come to apply for positions to be on these boards, whether it's the Board of Appeals, whether it's the Planning Board or the Planning Commission, depending upon what county you're in. And essentially, we have to rely on people it is who are certified planning technicians. I can only speak for Charles County in this one, but I know that the planning technicians, they do have their certifications from the AICP. I don't remember what those initials stand for, but it is a state certified process that they go through. And the record extract does include the staff report, and it goes through all of the technical requirements that need to be considered for this any project to be considered and brought before them. Because, and I know that I've actually, as a matter of process within Charles County, we've tried to make sure that we educate many members of our planning boards, because they really don't have a clue other than why am I sitting here in traffic for so long? Or who on earth authorized all of those big buildings to be over there? That's the only thing that they understand. So they do have to rely on the technical analyses that are provided by the technicians in the staff report.
That's pretty common in the world of administrative law too. But I have to say, this is the first time I've never known what it is we're reviewing, other than a binary yes or no decision. Usually somewhere, yes, this with citizen commissioners or people with whatever expertise they do or they don't have, but they do in some manner have to articulate what it is they've decided, and in some even limited way, why. And maybe in a case where there's an application and nobody challenges it, it can fly through. But in any instance where somebody has attempted to challenge it, at the very least you have to say, we disagree with this challenger. And maybe you don't have to write a 50-page opinion going through every jot and tittle, but you have to say something. I find this argument not credible. I think this is outside the statute or whatever. And sometimes it's done on the record. Like, there's a lot of fluidity about the format. But I confess that this is the first time where the argument is all we have to do is say yes or no, and we don't have to tell you why. And how we're supposed to determine whether that's arbitrary and capricious or whether it's supported by substantial evidence or not.
So I am going to respectfully point out that and I think it is a matter of routine and it's very common. It's something it is that has been taken to task on other cases in circuit court where the planning commission has made a decision and has said we're just incorporating these findings. Whether or not a body decides to further elaborate on the record what it is that they're discussing is not something it is that I can necessarily make somebody do.
Where in this record do I go to find where the decision was made to rely on the staff report?
In the final motions that were made by the court, I believe, by the planning commission.
It's simply in the minutes of the meeting,
Yeah, I was gonna say
because
the
the minutes, for example, the minutes from July 20th simply say, applicant and his representatives answered additional questions. Motion was made by Mr. Barnes to approve the site development plan with the findings and recommendations included in the staff report. That's all, and that's all it says. And then the problem is that at page 164 of the record extract, where the transcript, the chair says, well, we learned a lot tonight that was not in the staff report. And then somebody else who's on the planning commission, who's unidentified, I guess the speaker, they couldn't identify who it was, to the degree that we learned info to be included in our endorsement and comments, that shows we considered the full impact. But nothing is included in the comments that the commission, in the minutes, there's nothing mentioned about any of that, so.
You said page 164 of the record
Yes.
extract?
Mm-hmm.
As I recall that hearing, I'm going to move us ahead to the issue, the motion that was made on the extract in page 179 to 180. Actually, this was a one where everyone was asking for some additional information. But I do believe that the motion that was made was one that reflects the decision of the Planning Commission, and the decision of the Planning Commission was to to approve the site development.
I mean, I guess this colloquy sort of proves the point. we've got to go back and reconstruct out of the transcript of this hearing what the motion, the second, and the vote was to figure out what we're reviewing in the first instance, right?
I don't believe so. I think that the staff report clearly identifies what it is that they're here for, what it is that was presented, what
Well,
it is
if
that was
the-
analyzed.
If the transcript of the hearing reflects that there was evidence or testimony or documents or data or anything offered or considered beyond what was in the staff report,
Okay.
then the decision to approve the application goes beyond the staff report, right?
Potentially.
Potentially. And so the potential, now they could also say, well, we disregard all these other things that came in. But, and I don't want to make you stand there while we watch you find it, but where's the motion that we can say embodies the decision that was approved?
You might have to ask me to.
Well, the motion's at page 172. I can answer Zarian's question there. But
A motion that the planning commission approve the site development plan, yada, yada, shall include the findings that it will not adversely affect the adequacy of public facilities, blah, blah, blah. And the planning commission adopt the findings and recommendations incorporated within the staff report today. I will second that, and then that's approved.
that's not what the minutes of the meeting say that the motion was.
So what are we reviewing?
So I'm going to say that as a matter of practice and routine, and I think that this is something that's become extremely common when we are talking about virtual hearings, when things are recorded. We do retain all of our recordings, and those have sufficed as minutes, as the basis for the minutes. Our job is to make sure it is that we provide enough information to the public so that the public can see that there was something that occurred, that there was a decision that was made, and it is memorialized.
Okay, so what is the public what is the substance of the decision that the public can rely on having been made now?
That
If
the
there's a
site,
discrepancy between what's in those minutes, what's in that transcript and what's in those minutes, what is it that the public is to know has been decided and will be enacted?
that the site development plan, which really requires the finding of the planning commission to say that there is no adverse impact on the adequate public facilities, it has been granted. This now, like I said, I'm going to back up for just a second. I know my time is running short, but the issue here is not the simple approval of something new. It's really the planning commission being able to make that basic finding that it doesn't have that adverse impact on adequate public facilities. This is not something that's new in zoning. It's not something that is anything other than a new use.
And I guess the inference then is the finding that there's no adverse impact means that we've also rejected by adopting the staff report, we also are rejecting all arguments to the contrary. I mean, this is a contested application, right? There are people saying there are going to be adverse impacts. Mm-hmm. Those are not addressed in the motion directly, but is it the...
That's in the nature of
your position that the decision to adopt it with the staff report means also that any challenge is being rejected?
If their decision is to simply accept what it is that has been presented, then implicitly yes.
For what reason?
That the analysis that was provided by the staff meets the compliance, which is something it is that they are supposed to be looking at. Does it comply with what it is that the legislative body has said, this is what has to be met? Legislative body has said, this is the standard. The staff has reviewed it to say it has met all of the standards, and that is what the Planning Commission has accepted or made the motion for. I hope I've been helpful.
Any other questions? Hearing none, thank you very much, Ms. Theobald. and
Thank you.
Mr. Gill, for your arguments this morning. Both cases are now submitted.